Hello, welcome to Chapter 5 and the theory on agencies. The big picture is agency law could be a question in its own right, but it's also important to appreciate that the underlying principles of this area of law could also appear in the context of partnership or a company. In other words, a partner acts on behalf of a partnership, they're an agent, and directors act on behalf of shareholders in a company context. Questions can be either pure knowledge with easy marks available if you've learned definitions. So again, not difficult, but you do need to learn them. They can also, the questions form a more practical nature where you actually have to apply your knowledge to a given scenario. The examiner sets out a little scenario to which you have to apply your knowledge. That's how it works. Okay, so what's the formation of an agency relationship? It's basically where you have an agreement, consent between two people, three people, ratifying the subject that is going to be undertaken and the various conditions, and the operation of the law in which they were going to operate. You also have implication, estoppel as they call it. You can have implied agents. So an agent could be implied to act on behalf of someone else. Okay. Now, an agent is basically somebody who acts on behalf of a principal. So a classic one would be a football player will have an agent act on their behalf when sorting out their contracts, their remuneration, which club to join, etc. That's the most obvious form of agent, is a football agent. Estate agents act to sell your property and they show potential buyers around. Now, the authority of an agent to enter into legally binding contracts on behalf of the principal can be recognised in a number of ways. They can have actual authority. In other words, they're told expressly by the person who, like the footballer or the person selling a house, you are acting for me. But also it can be implied simply by their activities and the nature of the contract. But it does need to be communicated to the party. Apparent authority, this most commonly arises as a result of an agent having been held out as such by the principal. So the principal makes other people believe that this other person, the agent, is acting for them because they've held them to they've mentioned them in documentation and stuff like that. Now, duties of an agent. Common law duties of an agent are normally seen as being quite a list of people, of things, which in simple terms you'd expect someone to not delegate on. You'd expect them to act within the authority as given to them by the principal and the contract that they've signed up to. You wouldn't expect them to have any conflicts of interest. So for instance, a football agent negotiating with one football club, you wouldn't expect them to perhaps be the owners of that football club. You wouldn't expect them to have any secret profit, so you'd expect everyone to know about what their terms and fees are for acting for the principal. You expect them to obviously act with due skill and care, confidential, all these sort of things. Agencies can come to an end. They can be done by an agreement. Maybe it just lasts until the house is sold or the contract is supplied as a footballer. Clearly, if there's death or insanity or one of the parties goes bankrupt, then that will normally bring to a close the end of the relationship. The UN has a model law on agency, which basically, given the tripartite situation where you've got the agent, the principal and the third party, there is great potential for conflict of laws in the event of a dispute arising. What the model law then sets out to do is dictate which national law should apply in the event of a dispute. i.e. which country will the dispute be sorted out in. If you don't have such an agreement in your contract, then the model law will apply. The one exception to the above will be if any country connected with the agency relationship has relevant mandatory rules which would override, and therefore these would be the ones that are applied. The model law, agent v principal, basic rule, law of the country where the agent had the place of business at the start of the relationship. As always with law, there's an exception. Law of country where principal has place of business if agent acting in that country. So slightly different. NB, if no place of business, then place of business is treated as being their habitual residence, where they normally reside, live. If, however, you have more than one place of business, use one most closely connected with. Model law, agent v third party, basic rule, law of country where agent had place of business at time of their act. This also applies where the agent does not deal face to face with third party. Okay, so it's important to understand agency theory. Agency theory is where somebody acts on behalf of a principal when dealing with a third party. They can have explicit authority, implicit authority, various forms. It's worth looking at this in the book, but also bearing in mind it can be a partnership as well as a limited company scenario. Good questions often come up, little bit to learn, but not too difficult for learning, just things to remember. End of chapter. See you in the next recording.